Welcome everyone to another bulletin from Top Notch Legal. Today we're going to talk about some employment considerations. A number of issues have cropped up recently with clients, and I thought perhaps it was time to address some of these issues and to fill you in so you have a bit more comfort about what you should be doing with employees, whether they're casual employees or contractors, essentially what we're going to talk about, and issues regarding confidentiality and moral rights. Now, the issues that come up are these people employees or are they contractors? Now, if they're a casual employee, then what are my obligations? Do I need to have a written formal agreement in place with them? Now, sometimes there's a very fuzzy line between whether a person is a casual employee or a contractor. Now, a contractor is expected to work for more than one business, and often they'll be a sole trader. So really you have to look at them and say, well, do I regard this person as being in business for themselves? Because that's who a contractor essentially should be. You expect that they will supply the skill and equipment needed to perform the job. Now, if we often think about young people who do bar work, very often they're students or travellers. Now, you might say, well, okay, they work for a particular pub on a Tuesday and a Friday night, and for a restaurant on a Wednesday and a Saturday. Now, they might say, well, on the basis that I provide the skill, I have learned my skill travelling the world, I bring the skill to this job, I think I should be regarded as a contractor. But really, they are under the direction of the employer. Also, there's no expectation about further ongoing employment. And generally speaking, it's regarded in that industry that those people are casual employees, not contractors. And sometimes we have to look at tradition to, a lot of lawyers would disagree with me, but the lines are so fuzzy between casual employees and contractors. I think sometimes it's useful to look at tradition to see what's traditionally been the case. That doesn't mean to say that it's how you govern the issue, but it can help. Now, many people seem to think that if someone's got an ABN, they are automatically a contractor, and that really is wrong thinking. The courts have often held that someone with an ABN is not a contractor, and really it's quite irrelevant to whether, in determining whether or not a person is a contractor or an employee. Now, someone that doesn't have an ABN and who's earning less than $75,000 per annum is not required to have one, but still could be a contractor. So you have to look at these cases individually and ask the question, all the issues around, okay, are they working for themselves? Would I regard them as a sole trader, etc. Now, if a person is hired as a contractor and you don't have a formal agreement in place, the issue has come up a number of times before me. Okay, so what sort of notice do I need to give them? Because it's time to call it quits. So I would recommend, to be on the safe side, that if you're paying them weekly, give them at least a week's notice. If you're paying them monthly, give them at least a month's notice. Now, a contractor should submit invoices to you for the work that they've performed. Now, with casual employees, their situation is governed by the Fair Work Act. Now, because they're not entitled to all the usual benefits of an employee, such as holiday pay, long service leave, redundancy, etc., you are expected to pay a loading on top of their award rate. Now, a number of awards require a loading of at least 20%, but it does vary from one industry to another and from one state to another. So if you go to the Fair Work site, you will get a lot of very useful information there. And superannuation must be paid to these employees who are earning more than $450 gross per month. Now, looking at this issue, whether or not you need to have an agreement, a written formal agreement with these people, I think what you need to be looking at, well, what do I have to protect? If you've got particular confidential information that you want to protect, for example, say you've got a very precious customer list that you don't want your competitors to get a handle on, or you've got a particular way of delivering your services or products or whatever it might be there, with your business, and you want to protect that, then I would say highly recommend you have a formal agreement put in place. Now, if you don't, let's take a situation where an employee leaves you. Whilst there are common law principles that would allow you to sue that employee, if they've already let the information go, it's very hard, as I say, to put the genie back in the bottle. Now, I want to just take a small example here. Say you have a business building websites and you hire Tony. You've got a number of creative types in the business and Tony's one of your top performers and he leaves to go and work for someone else. Now, he doesn't pay a lot of attention to rules, not to say he disregards them, but they're not high in his priority and in his thinking. So he leaves you and he's very proud to share with his new employer some of your top customers. And before you know it, your customers have left and gone and worked for your competitor. What can you do about it? Well, yes, you could probably sue Tony. Certainly you could if you had a formal agreement in place. But once the customer's gone, you're probably not going to get them back again. So best to get it right when you start off. Now, another issue here is that creative types have what we call moral rights in the work that they create for you. The essential right that they have in that work is that they can prevent you from altering the original work. If we take the example of the business where you build websites, they've got to be updated on a regular basis. And an employee who has now left you, they could exert moral rights over that work. So I would recommend that you have a formal agreement in place with your employees. It's not unusual to ask them to assign over those rights for any work they create whilst they're employed by you and paid by you. Now, it's very important to get these relationships right. I've known of several cases, law cases, plus personal situations where a person's been hired as a contractor. They may have even asked to be hired as a contractor, have then left and become disgruntled because they didn't get redundancy pay or they didn't get holiday pay or some other benefit. Now they want to claim that they should have been hired as an employee and they sue the employer. Not a good position to be in. I know of one case where the so-called employee sued the employer 10 years later. So you can see that it is important to get these situations right. And again, get legal advice. It's not expensive to ask for advice. You may pursue the advice, you may not. A lot of us lawyers will give you initial advice over the phone for nothing, but at least you get some guidance as to the direction that you should take. So that's all we have for now. Top Notch Legal, thanks for listening. We take care of business.